Hey, what's up, everybody? It's Stephen A. Williams, president and founder of thecreditrepairshop.com. In this video, I want to talk about some questions that I'm having from a lot of people who live in North Carolina, Pennsylvania, South Carolina, and Texas. If you don't know this already, those states, you cannot be garnished. You can have a judgment placed against you, but they can't garnish your wages. Like, they can't go to your employer and garnish your wages. But I want to make you aware that even though they can't do that, it's even worse. It's even worse. And you might be saying, well, Steve, how can it be worse if they can't go and garnish my paycheck? Well, let me tell you how it could be worse. These states allow debt collectors to actually attach and garnish your bank accounts. And the crazy thing about it is that they don't even have to go through all of the legal loopholes, or I don't want to say legal loopholes, all of the legal things that other debt collectors have to do to just garnish your wages. They could just do one court hearing, and then they can garnish the money right out of your bank account, all of it. You have no opportunity to negotiate, no opportunity to say, hey, you shouldn't take this money because I need to use it for my personal expenses. Now, yes, you can get the money placed back into your account, but then you're going to have an attorney, or you're going to have to go to court yourself. You're going to have to file all of this different paperwork to have the money placed back into your account. But this is a thing that they can do. And we're starting to see that a lot of debt collectors in these particular states are really taking advantage of this law to be able to do this. Like, here's the crazy thing about it. When I show you the debt that is being purchased, and that debt is past the legal statute of limitations to be able to be collected. Well, what debt collectors are starting to do with those debts is that they're like, okay, why go through the necessary court filings to get a judgment placed against them, to have them had opportunity to be able to, stop the lawsuit? Why don't we just use this law where we could just go and say, hey, they owe this amount of money. We want to attach the bank account and be able to get the money out of it. And the bank has to allow it because there's an attachment. It's like it's a lien against your bank account. This is something that they're using, and people don't even know their rights. Now, another question that someone had posed to me, they said, when I go to court, why are these debt collectors allowed to actually essentially sue me for debt that is potentially past the legal statute of limitations? Why are these debt collectors allowed to sue me for a debt that has been canceled by the original creditor, and a potential 1099-C cancellation of debt is being sent to me, or it has been sent to me? How were they able to do this? Why isn't the judge stopping it? This is the reason why. The judges don't even really know. They can look it up, but they don't necessarily know, and they're not going to necessarily tell you. Like, they're not going to be on your side and be against the debt collector when the debt collector is someone that they see every day. Not to say that they're going to be 100% on the debt collector side, but they're not going to just outright give you that information. If you are being sued and you are going to court and you need to just say, I need to catch my breath to see where I'm at with this situation, and you did not respond to the court summons in the appropriate amount of time to give the debt collector some time to review it, or you just disregarded it and you have a court date and you got to go tomorrow, this is what you need to do. You need to tell the judge, you need to tell him, I have not been able to review the court summons fully, and I've just been made aware of my rights, and I need to get more time to respond to the court summons. they will usually give you more time. If they don't give you more time, let me tell you what you need to request that they give you at the court hearing at that time. Is that you need to ask them for the documentation on who gave you access to my personal information. They're going to probably say, well, we purchased this debt from so-and-so. Okay, give me the affidavit of purchase showing my name, showing my specific complete account number for the alleged debt. And with that, it should have a statement authorizing you to have access to my personal information. Right there, just start right there. Let the judge, if you say that to the judge, they're going to look over to them and they're going to say, okay, that's reasonable. That's a reasonable request. Please provide that information. And I'm pretty sure what the plaintiff attorney is going to do. And usually they send the lowest of the low attorneys, like beginners or the ones that are just paperwork shufflers. They don't argue anything. They're going to usually either say dismissed, because they're given instructions. They're given instructions on what to do when they encounter certain things, because they don't want to get the company in trouble. They don't want to have any issues with the company. So there's certain situations that they would just say, dismiss it. I know this not from theory. I know this not from watching it on YouTube. I know this because it happened to me when I ran into my own situation in the 1990s. And it has happened for my customers, my clients that we have done this for. And they went right into court and we said, this is what you need to say just to try to hold things off. So they will either say dismiss or they're going to say we will grant more time. And then if they grant more time, then you need to respond to the court summons the right way. Not where you're just saying, I deny this whole thing. No, because that's not going to work. That's not going to work. They're going to say all you're trying to do is just evade. You need to respond point by point to what they're alleging. And then you need to have your affirmative defense with all of your points, making them, pushing them back up against the wall and making them fight. I'm telling you that from the court summons that we have responded to, when we respond back with the way that we do it, most of the debt collectors will not fight it. Most of them. I'm not saying all. There's some that will fight it. There's a few. I'm not going to mention their names. They will take this all the way to the limit. And I suspect the reason why they're taking it all the way to the limit is that they're promised a certain amount of money if they win, or they have been paid already a retainer and they're going to just fight it. Like they're paid a retainer to do a certain amount of cases and they're just going to continue fighting. There's two of them right now that like they take it to the limit. But regardless if they take it to the limit, when they take it to the limit and they respond back and they want more information, more detail, they're really just asking the same questions over again. When I say take it to the limit, they just try to keep making the client have to come back and give the same information over and over and over again. Nothing really changes. Because if you think about it, what is the basis of the whole suit? They bought the debt and they want to collect on the debt. What is your defense? How did they get my personal information? Validate fully how they came up with the claimed amount. And only the original creditor would have that. They will have like 2 or 3 statements. Show me the affidavit that shows my complete name, my complete account number that has my name. They usually get a piece of paper that'll say they did a bulk purchase and it'll have a lot number. It doesn't have your name on there. And then what they'll do is they'll come back and they'll have an affidavit that is produced by them, and they try to fake it to the court like that affidavit was made by the original creditor. The original creditor would never make an affidavit with your name specifically on there. They will not do that. Also, in your defense, your affirmative defense, you want the original creditor to state that everything that they gave to that debt collector in that lot number is 100% accurate. They will not say that it is 100% accurate. You want them to give an affidavit stating that it's 100% accurate. They will not do that. There are court cases out there that have went buck wild, for lack of a better term, but y'all know what I mean by that, where they sold debt to debt collectors, and the debt was either in a bankruptcy, it would either forgiven in a 1099-C debt cancellation of debt to the IRS, ID theft. Like, there are court cases right now that had those. So you want them to state that the information is 100% accurate. They won't do that. Excuse me. So this is the way that you fight it. You're not evading. You're making them answer these questions. Now, you might be thinking, well, they're going to say, well, you should know. Wait, hold on. I should know. You're the one that's suing me. You should know. You should have the documentation because you are accusing me. That's why they'll use statements like this in their court responses. This is how they try to butter it up with the court. This is one actually here that I'm finishing up today. It says here that the defendant established a credit card account with Capital One Bank, which he/she used to obtain goods, services, or borrow money, providing that he/she would pay Capital One Bank N.A. for goods, services, and money obtained. So what they want to do is they want to show the court. Now, you might be saying, well, why did they even put this in there? Why, if it's just about me with the money and that they own the debt and they just want to collect on the debt, why do they even go through putting that statement in the allegations? Because they have to. They have to make the court feel that you benefited from the use of the money. If it was just about the money, why they wouldn't put 9 or 10 allegations inside of a complaint. They would just say, you owe the money, we bought the debt, and you give it to us. They put that in there because they want to persuade the court. So what you do when you do yours is you need to put information in there to persuade the court to see your side. More information. Show me this. Show me that. Prove this. Prove that. Don't you see? Like, that's how I actually got really good at doing this. Is number one, I went through it, so I know the emotions that people go through. I know the how people feel. I know the anxiety, all of that stuff. So I know, and then I know the benefits of thinking accurately, thinking without emotion, responding without emotion, and just looking at stuff for it is for what it is, and I'm going to respond to it to the best of my ability, and I'm going to put it all on the table, and if I win, I win, and if I lose, I lose, but I'm taking the emotion out of it. That's the way that you win. That's the way that you fight, and sometimes you might lose. Sometimes you might lose, but that's okay, because what you did is you put all of your cards on the table and you just didn't let them just run over you. That's really the whole point. And you're going to win some. The thing about it is that you're going to win some, because you never know what they are thinking. You never know what they are thinking, and you never know when you make certain responses that they might say, we got in trouble with this in another state, and we don't want to get in trouble with it here, or this judge is known for when people respond this way that they just dismiss them anyways. You don't know that. That's why it's always better to just respond, put it on the table, and let's see what happens. All right, I'm going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, where I'm going to display my 8-point validation process. That's the way that we repair credit. 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, and I want everyone here that is listening to me right now to help me support this channel, my time coming here giving you this great, excellent, important, valuable information. Go get your credit reports and scores from the number 3scores.com. Link is below this video. If you have debt collectors coming after you, you can stop them early before it gets to stuff like this. Grab my 3 letters, my statute of limitations letter, debt validation letter, cease and desist collection activities letter. The link is below here. Use those. Use the one that's appropriate. I have instructions above each. Use the one that's appropriate for your specific situation. Please like this video. Please share this video. Please comment. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.